live.
Okay, good afternoon. This is the Board of Standards and Appeals, September 14, 2020, 2 p.m. review session. We are going to recall a case that was for the decision for this morning. Item number 11, 2019-7BZ, 3341 Country Club Road, the Bronx.
Okay, so we had asked that they submit an entire package of drawings signed and sealed with the proper date. And they submitted a package, but there's still a problem with it. So Commissioner Shanda, you want to?
Okay. So the difference is really between the plan that was submitted dated September 10th, 2020 and the March 26, 2020 submission. And the difference is the two-story stucco frame building for the roof line that I'm seeing, that is on the conceptual plan of March, is different from the roof line or whatever the building line, if you want to call it, building footprint, that is shown on the 910 drawing. And in addition to the staircase, I understand the much clearer notes have been provided in the 910 drawing indicating which stairs are going to be removed, but those are not reflected in the same manner in terms of the staircases on the March 26 drawings, and specifically the building footprint that is on the portion of the site that is within the DEC jurisdiction. If you look at the building juts out and there is a small little square that juts out of it where as part of the March 26 drawing, but that's not the same footprint as shown in the September 10th footprint. So it's just having consistency in the footprints and of the drawings, and since they are all going to be part of the same set, mm-hmm. and also then making sure that the floor area is also consistent.
Okay. Did you find inconsistency in the floor area?
Well, I don't know then which is the final floor area. Is it the March 26th, the final floor area, or is it the 910? What is the building footprint, the 910 or the March 26th? Because that would then may result in a different floor area count.
Okay, so that I can follow along, and so you're looking at drawing, which number drawing?
I'm looking at the March 26 drawing, conceptual site plan BSA 1.0. And I'm looking at the plan, specifically the building that says two-story stucco and frame building. And the two-story right now, as part of the March 26 plan, it's a square building with another kind of almost of a square that's jutting out of it.
So the other thing that I want to point out, though, because I'm trying to follow and then I'm looking at the designations on all the drawings that were submitted just now, completely confusing. There are so many dates on these drawings. So if you look at the first one, BSA 1 that was just submitted, the date is 12/14/18. The drawings have to be dated recent dates. We can't have old dates. That's the first. They need to be now dates. And then
good point.
What?
Good point.
And then the next drawing, which is labeled BSA 2, is dated October 9th, 2019 and revised February 25th, 2020, which is earlier than the set that you're referring to, the March set. So is it even the latest set? And then the section that they're showing here, which is dated October 9th, 2019, is a different section than the one that I was referring to from from March. There was a different set of sections. So all of those should be included. I think maybe rushing the architect to get the stuff out was not helpful. They need to take more time. And then finally, we do have those two September 10th, 2020 drawings that were just submitted. They're in the set. So I would like the applicant and architect to spend some solid time coordinating the drawings and making sure that what there is on the drawings is consistent and that there haven't been any changes that we're unaware of on the set that we consider the set that we sort of negotiated with the applicant, in the sense that we said, you know, fencing here, landscaping there, all of that. And if your drawing is from February 25th, then that's an earlier set, I believe, than the March something one that you were looking at.
I'm
Right.
looking at the March one is the submission, and in that one, you're right. The drawing date is listed as October 9th, 2019.
And it wasn't shown as revised February 25th.
Mm,
On the lower right below October 9th?
no.
Okay, so that's the thing. We don't know what's going on.
Yeah, I'm going by the submission. That I'm looking at the plans that were submitted on March 26, 2020. That's the plan I'm referring to. That's the latest I at least see.
Right. But and that one only has a drawing date on the drawing itself of October 9th, right?
Yes.
So we were just given a drawing date of February 25th, 2020, which therefore is a drawing we've never seen. So we need to make sure that, and what I would like them to do also is to take all the bubbles off the drawings and only bubble something that's changed between the March 25th submission, or whatever that, March 25th? 26th submission and now. And if there were any changes, then we'd have to decide whether they're material changes or just, you know, some little note. Because the bubbles draw our attention to potential changes since the last submission. The only bubbles that should be shown are a change from the last submission to the newest one. Okay, so I hope this is Daryl's applicant. So if Daryl could clarify that with the applicant today, now, in fact, maybe on a call, and try to get a resubmission as soon as possible so that it can be looked at and made sure that it is consistent throughout and that all the dates are current dates. In fact, today's date. Yeah, Commissioner Sheta?
Yeah, I would say as like an advice to our PMs for all projects, when a new revision is submitted, clouds and a certification on the new submission that says nothing other than clouded is changed from the previous submission. And it should be some sort of like a penalty if this certification or this statement is incorrect. Because we're not supposed to review every submission from scratch, from like day zero. It's going to be very time consuming.
Yes, agreed. Well, so in this case, you know, what happened was, and project managers have to be aware of this too, we must have a complete set of drawings before we vote. And it can't be that we're taking a drawing from here and a drawing from there. And I thought we made that clear at the last hearing. And then we end up getting, you know, we still had these haphazard drawings all over the place and having to try to put together our own set. One from A, one from B, one from April, one from March, one from this, right? You cannot do that. We must have a complete set of drawings, all with the same date. Otherwise, it's really impossible for us to know whether we have the final set. And also the our counsel's office can't write the resolution because they don't know if they have what's considered final. Okay, so I don't think we can say it any clearer than that. If the applicant is listening, hopefully reach out to our project manager, Mr. Ruffin, if they need any clarity. But please take a careful look at the drawings before you submit them, applicant, and make sure they're all coordinated, okay? All right, let's move on to the next one.
Okay, appeals calendar, continued hearing item 21 and 22, 2017-16A through 2017-19A, 15-5862 Clintonville Street and 150-9395 Clintonville Court, Queens, and 2018-105A, 150-87 Clintonville Court, Queens.
Okay, there's sort of a lot of ongoing things with this. Just when we think we have sort of the answer, we don't have the answer. But I do want to say that that in this case, we directed the applicant to reach out to DOT to see how they could take advantage of the existing map street that is 16th Road that connects directly to 150th Place. And they submitted to us a really nice looking site plan that has access from 150th Place and access also from Clintonville. But then they were getting bizarre, frankly, responses from DOT that said either you improve 16th Road all the way from 150th to Clintonville, or you buy the land or no deal. So we actually reached out to DOT to say, you know, what they're proposing is a much better site plan than what they would be doing with either with a GCL 35 waiver or both a GCL 35 and a 36 waiver. And DOT's objection had been that they're creating like a dead end that goes nowhere. Well, they'd be doing exactly the same thing, only not in nearly an organized fashion. If they had to get a GCL 36 and 35 together. And in addition to which, we had said at prior hearings that we thought they should go ahead with only a GCL 35 waiver because it wasn't clear they had proven a hardship. So, and I'm not sure whether commissioners would feel the same way after all the work they've been doing with DOT. But what we learned is that DOT is now reconsidering the request. And the applicant has asked for more time, but they might want to speak. Tony, did you want to say something?
No, that's what I was going to say. That the applicant has been, the attorney for the applicant has been speaking to DOT with some options, and they're going to require at least a month in order to work with DOT on some of these options. So
Right.
they're going to mention.
They asked whether they should adjourn or whatever. That's sort of their call about whether they want to speak. But what I would ask them to do, and I thought we had asked them to do it at the prior hearing, and we didn't get that, was we were trying to have two solutions, both of which would be acceptable to the applicant. One, this one that, you know, I'm promoting because I think it's a really good site plan, the one that they submitted to us with the little turnaround coming from 150th Place, and then 4 houses. So that's a turnaround for 2 houses, plus 4 houses that face Clintonville Street. So that's a solution. And then another solution that is the 4 houses or whatever facing only having frontage on Clintonville Street. And when I was looking at the drawing that they submitted to us where it's got the 2 routes to access, and a recent application that we had where the applicant argues that, and now you have to look at the drawing that was submitted with this circular turnaround. There's 1 house set back from the 4 that are fronting Clintonville. And it, according to another application we saw, technically has frontage. So, wouldn't that just need a GCL 35 and then you could get 5 houses on the site? That's kind of my question, and maybe that's why we should actually have the hearing. But I think that the applicant has to have in the submission the alternative in case DOT says no. The applicant misunderstood our request, I think, and said, I already submitted that. That's the as of right drawings that were submitted a long time ago to make the hardship argument, which didn't have what I considered to be believable buildings on them. In other words, that you would really want to build that. So the applicant should understand that we might, depending, I don't know how different commissioners feel about this, but that we might opt only for the 35 waiver, in which case there's either 4 houses with frontage on Clinton, or maybe this setback situation allows you to have 5 houses with access, legitimate access to the house from Clintonville, even though it's set back further. But it's not a house behind a house situation. It's got its own kind of front yard condition. So then I go to Vice Chair Chanda.
I think I'm in the minority. I did not have an issue with the previous plan, and I don't have an issue with this current plan. Of course, the current plan that's been submitted is very much contingent upon city agencies agreeing to sell the property or making this property accessible as a viable roadway or a roadbed. That would still remain under city jurisdiction. I'm not sure how that gets resolved, and I guess those are the discussions that the applicant is having. With the city agencies. So, if that is feasible, then yes, sure, this plan would work too. I really don't have an issue.
Okay, Commissioner Ollie Brown.
I hope actually that we can prevail with DOT, because I would hate to see the property owner deprived of their rights to have all 6 homes, because I really think that this setup actually would be better than having one home still behind the other homes, even though it has appropriate access. I just think it's not as valuable a home. So
Yes.
my preference would be for them to prevail with DOT, who really shouldn't be as concerned because it isn't in any way affecting their capital projects. So I'm a little concerned that they might be stepping a little too far over their jurisdiction here, but let's see where we end up.
Okay, thank you. Commissioner Sheta.
Thank you, Chair. I agree with the Commissioner Brown, and I believe that the current layout or the current site plan is a little bit better than previous, and I don't have any further comments. Hopefully, we're gonna vote on this soon.
Yeah, so we're hoping to. Okay, and Commissioner Shibeta.
Nothing further from me on this, Chair. I hope that reason could prevail on this.
Okay.
Move on. Item number 23, 2019-281A, 965 Richmond Avenue, Staten Island.
Ongoing discussion about the cell tower. Okay. I think I still have a lot of comments, but that's why it's a lot of scrolling before I get to the beginning. Okay. We have submissions from, just as to alert both the appellant and our commissioners that everybody read all of the materials they were expected to read. We have a submission from the appellant on July 22nd, from DOB on August 13th, and appellant's third reply on August 26th. Appellant was asked to explain OmniPoint's statement in BSA calendar number 287-05A that a cell tower is neither a quote telephone exchange nor a communications equipment structure. And it kind of attempted to do that, or it did that, but I have to admit I didn't understand the explanation in the statement of facts. So if they could discuss it at the hearing, that would be helpful, and also to point to the text itself for support of their statements. I felt like it was kind of rambly, and I just didn't understand it. And as a reminder, BSA, just for everyone, BSA 287-05A concerned DOB's authority to issue technical policy and procedure notices, and specifically took no position on DOB's determination of the use of that equipment. So BSA specifically said we take no position, but the Department of Buildings has the authority to issue these clarification technical notices. The TPPN that I'm talking about addressed the question of, quote, cellular antennae and, quote, related equipment. At the time, this referred to the relatively small antennae that could be mounted to parapets of residential buildings and to the boxed equipment that was located on the rooftops or maybe in the rear yards, I'm not sure where. It most certainly did not include the monopoles onto which those antennae might be mounted. And also, I read that the trigger for the 7314 special permit was the inability in the TPPN, was the inability to fit within the size limitations set forth in the TPPN, and not that any equipment of any kind that didn't comply with the TPPN would be designated use group 6. Only that the cellular antennae would be designated that way if it was larger than the limitations on the TPPN. So that doesn't go at all to the structure onto which they're mounted. From a policy perspective, I asked this question: did the 1998 TPPN anticipate too naively that the as-of-right antennae installation it permitted would be used moderately or with caution by the cell phone industry? And 20 years later, it now realizes that the TPPN instead allowed aggressive industry practices with unintended consequences that now need to be tightened up and better regulated. Hence, DOB elects to disband the TPPN and clarify what is as of right and what isn't under a tighter reading of the zoning resolution. I think that's kind of what's happening. It's kind of like a retooling, having opened the gates too wide and then the flood indeed poured in. And concerns about unregulated heights of the structures on which the antennae are mounted may or may not be founded by current industry intent or practice, but may certainly be a concern in the future. Nonetheless, the BSA has seen some pretty terrible looking poles and, quote, stealth structures, which is what the cellular industry calls them, and rooftop antennae forests inappropriately proposed and in conflict with neighborhood characteristics or exceeding FCC exposure limits that would, absent BSA scrutiny, go unchecked. So it's not as if there hasn't been a need in our various reviews of an agent, of someone taking a closer look, because indeed there are times when they don't comply with various guidelines, either of FCC or there are such huge inappropriately scaled structures. And everything I read about the need for dense 5G antenna placements underscores the likelihood of this being our new reality. All the articles are about the frequency that they need to install these antennae to give enough coverage, that they have to be really close to each other, and but the poles tend to be more like 30 feet high. But meanwhile, I've seen 5G installation on one rooftop, and the equipment, the boxes for the equipment are enormous. Appellant acknowledges that DOB has referred most cellular monopole applications to BSA for 7330, not 7314 special permits, which apply to radio and TV towers at 7330, and that BSA rarely sees applications for actual radio and TV towers. So I don't see how that specific referral is a distinction without a difference, as appellant states in its submission. It is a DOB determination and BSA acceptance of the characterization of the use and the appropriate discretionary action to allow that use. When DOB sends us something for, say, a special permit, but characterizes it in a way that we don't agree is the right characterization, we move it into a different special permit type. And we'll say that, you know, DOB may have properly denied the application because it doesn't comply with zoning, but it's the BSA's job to figure out which special permit is appropriate, or if there's other special permits that are appropriate. I'm a bit confused by the statement in the appellant's letter that the 7330 reviews are type 2 actions. They are type 1 in nearly all of the resolutions cited in Exhibit 2 that was submitted on July 22nd. They may have been subsequently designated as type 2, and maybe Tracy could comment on that, but none of the resolutions that we looked at, or maybe just one, had it designated as a type 2. They were type 1 in all of the others. And with respect to the use characterizations in the BSA resolutions under 7330, the excerpts that were taken by appellants are the quotations from the DOB objections, not the BSA's characterizations of the use. So you look at those little excerpts and it starts off with a quotation from DOB in its objection. So if DOB is calling it use group 6, but saying that it needs a special permit, that's not us, that's not BSA characterizing it that way. We always quote the objection in our resolutions. And I don't think actually anyone is denying that cellular service is a quote public utility. The question is whether the cellular equipment mounted inside or outside of a monopole is akin to a radio or TV tower, which is also a form of public utility regulated by the FCC and local public service commissions. So according to that, the radio and television tower shouldn't be treated the way it is being treated. BSA could not have heard the applications under 7330 if it did not believe the tower should have been characterized as radio and TV towers. That is a threshold jurisdictional finding. So that, as I said before, we have to decide what the thing is before we decide which special permit it qualifies for. Furthermore, the Rosenberg case notwithstanding, in Con Edison versus Hoffman, the 1978 Court of Appeals case concerning the Indian Point power plant, the court held that although a zoning board may not exclude a public utility from a community in need of such facility, quote, this has never meant that a utility may place a facility wherever it chooses within the community, unquote. DOB has said as much in its papers. The community has a right and the governing agencies a duty to protect the public from indiscriminate and unplanned siting of such structures. However, there's no question to me that there has been inconsistent application of the interpretation, and it is up to DOB and within its authority to amend its policies to improve consistency. And lastly, I'm not really understanding appellant's objection to obtaining a special permit for the proposed monopole if, as it states, such applications are rarely sought and the 5G network wouldn't reach the issues considered here. So I'm not really understanding what the fuss is about if in this case. So those are my comments. Vice Chair Shanda?
Okay. So in the documents that have been submitted, DOB states that the freestanding cellular antenna tower possesses the land use characteristics of radio towers and therefore must be classified as such. I did not see strong evidence that was provided. It was an assumption, and that is based on DOB's reference to 1970 text amendment, and specifically DOB states in reference to the 1970 text amendment to use group 6D that at no point did the commission contemplate regulations for freestanding monopole antennas as part of use group 6D because such structures were not approved under use group 6D, but that required a special permit. First of all, at no point did the industry or the author of the zoning resolution in 1970 knew the possibilities of cellular network industry, and more so that such a structure could look, what that structure could look like. So it is a guesswork at best to assume that the City Planning Commission then assumed that all monopole would fall under special permit. There's no documentation that has been provided that leads me to think that way. As the cellular network service grew, the regulations have been expanded to allow the cellular antenna use as an as-of-right use, including in a residential district, through the TPPN 598, provided it is on the roof of a building and meets certain requirement. A standalone monopole in an R district would require a special permit under 7330. But the TPPN did not state that any monopole, even in C or M zones, would require special permit, except that, quote, to the extent the antenna and related equipment do not meet this criteria, that is the criteria set in TPPN, they may be classified as use group 6 communication equipment structure. The analysis provided by DOB of applications of cellular antenna shows that there is a consistency in the DOB's assessment, as you pointed out, Madam Chair, that what has been quoted are objections that are written by DOB. These are not the BSA codes, but it was telling in that sense that DOB, in its objection, in most of the cases, all the cases with the monopoles, 14 cases that were shown, 5 of them state that the monopole is use group 6, not allowed in residential district, because these were all just purely in residential district without a commercial overlay. And therefore these sites did not comply with TPPN 598, and therefore a special permit was required for that. Similarly, 7 monopole applications that did make reference to use group 6, there were 7 applications that made no reference to use group 6, but stated that the monopole is in residential district and require a special permit. Again, consistent with the TPPN. There were only 2 monopole cases that were in the commercial district and in manufacturing district that required the special permit. And in that, one of them, I think it's the one in the M zone, that stated, as per the DOB objection, that the monopole exceeded the sky exposure plane and therefore warranted a special permit. So there seems to be an inconsistency in the way DOB has applied when a monopole should get an objection and therefore seek a BSA approval. What is consistent is that when a monopole is in residential district, then it seems to go to the special permit line clearly, but definitely a consistent review pattern has not been shown with regards to monopoles in C and M, especially when we have received prior applications, prior list of applications where DOB has allowed monopoles in C and M zones as of right. The other thing, what I found interesting in this subsequent submission is that DOB has narrowed its concerns with regards to the antenna only to the building form and the built context. And it is not the similarity in its operation and function of the radio TV antenna and cellular antenna thereby. It is focusing mostly on the built form of it. So DOB has provided a theoretical exercise, and based on the comments received from the appellant and from what I was also over the time have been reviewing about cellular TV antenna of different types, I would tend to agree with the appellant that the analysis that was provided by DOB was done without really assessing the technical and the operational needs of the cellular industries. It was really just kind of saying, what is the sky exposure plane and how tall can it go and how big can it be? Typically in the city area, you're not going to see a 400-foot cellular antenna. It's going to be more in the farmland or out there where you need to spread it out. But a 5G also as a network system, it really does not cover a larger area, it covers a smaller area. So therefore you need to have more of the 5G antenna nearby compared to 4G. 4G has a bigger coverage area compared to 5G. So having a taller antenna doesn't mean the reach would be greater. It still is limited in terms of the coverage area. The 1970 text amendment to the 32-15 use group 6D was more done as with regards to the nature and the size of the equipment that mandated that it be housed in a massive structure containing floor heights which are greater by 50% or more than floor heights in ordinary office buildings. So the bulk regulations were modified to protect the character of the neighborhood. I get that, and that is the concern. In this case, in a C22 overlay in an R32 district, the height limit is ranging from a 30-foot height for a residential use to a community facility building like college or hospital that would be permitted as of right. That would have to be built based on a sky exposure plane above a street wall height of 25 feet. So if the use group 6D bulk regulations were applied on the subject pole, does the height quote exceed that attributable to commercial buildings of equivalent lot coverage? If so, then maybe there's an argument that could be made. Then I think there is an argument that can be made that it warrants a special permit. That analysis has not been provided. So basically what I say, if I'm going by those two monopoles that require special permit in C and M zone, in the M zone one, it says it exceeded the sky exposure plane, therefore it required a special permit. My question is, was that exercise, was that analysis done in this case to see whether this exceeded the sky exposure plane, similar to the ones that were done for the monopoles in C zones and M zones that required special permit, and then make that argument? I don't think that has been done, and I don't think this site exceeds the sky exposure plane. So there is inconsistency in DOB's review, and I understand DOB's concern, but I am not sure I'm convinced by DOB's argument yet. So the other part is the...
Before you go on, I just want to clarify, we had a recent application where it was discovered that the monopole or whatever exceeded the allowable bulk. And we had extensive discussion about the special permit 7330 not being available for bulk modifications. It's a use special permit. And if it was used by the board to allow for a bulk waiver, it was our view that that was an incorrect use of the special permit. So,
okay.
So yeah. Okay, so continue.
Well, in this case, the other part is, here the, okay, I'll end there then. That's it.
Okay, thank you. Commissioner Ollie Brown?
So I agree with you, Chair, that the major issue here is classification. Is this a radio TV antenna or a communications equipment structure? It seems like anything deemed a communications equipment structure had more simplified and streamlined procedures unless the applicant exceeded the max square footage of antenna and equipment and was located in a residential district, and radio and TV antenna being far larger had a more extensive review. But it seems to me like DOB never definitively classified cellular monopoles as either. It seems like it was left to the different borough commissioners to choose one or the other. And now DOB is having a knee-jerk reaction to the potential for the proliferation of extremely tall monopoles. And I'm not even sure if it's a potential that's ever going to play out. So my question really is, which agency, DOB or city planning, actually has the right to change a policy direction that wasn't necessarily wrong when it was based on both the zoning resolution and the TPPN? it seems like TPPN 598 was written with the Rosenberg interpretation in mind, in that every effort to streamline and facilitate the proliferation of cellular equipment and technology should be taken, since cellular service was a public utility. So is retooling of a regulation as technology changes the same as correcting an erroneous interpretation? And if it isn't, then does DOB have the right to retool a regulation without some kind of public review process? Or should this be refined at city planning and then handed back to DOB? Those are my issues.
But I just want to add that we know that there have been a lot of discussions. We're aware of it because it's in the papers, and we're aware sort of in the atmosphere that there's been a lot of discussion by the administration about the proliferation of the 5G, and hence the rationale for DOB taking another look. That's all I'm going to say, because it's fair what you're saying. Commissioner Shetto.
Thank you, Chair. First of all, I want to mention that I believe DOB has the right to look at its own policy and try to amend them if necessary. But like the applicant mentioned in the previous submission, I believe there are many monopoles that were granted in C districts previously by DOB as an as of right. And since 2018, I believe the DOB started to look at the TPPN and look at how they look at these monopoles. But there was a question in the submission from the appellant, this submission, that question actually, how many cases does DOB starting to look at these grants, these permits, and review them and see whether they issued the right classification to these monopoles as use group 6D. So that this is one of the questions that I would like DOB to look into.
Could you restate that? Just restate that question?
Yes. How many cases or permits or monopoles that were granted as of right in C districts, DOB started to review them and possibly change their minds on them. So if they have classified similar monopoles as use group 6D previously, and they granted permits, are they going to like revisit these permits and open them up? And I'm waiting for an answer from DOB on that. The second thing is, according to the appellant, and I agree with them, it sounds like the concern from the DOB on these kind of monopoles is a bulk issue. And I believe that the latest that one can worry about when it comes to a monopole is the bulk. It might be the height, yes, I understand, but bulk, I don't think a kind of structure like a monopole.
No, wait. Bulk is a term of art. Bulk is anything that's not use.
Yes.
Right? Bulk is height, width, whatever, anything that's not use is bulk.
Yes, I totally understand, but instead of like talking about the bulk, it might be just, reduced to just the height. It's the use was not a concern here. I'm not sure why this monopole is classified as a TV/radio tower. Yes, it emits radio waves that are necessary for phone communications, but is it really for a TV or a radio? I don't believe so. Right?
No, it's for cellular antennae. That's what it's
Yeah,
being.
so my point is, if it is for cellular, why wouldn't it be classified under other communication structure as per the zoning resolution? Is it a structure? Yes. Is it for communication? Yes. So I'm not sure why it's not classified as such. The other point, and this is in the DOB submission, DOB believes that Rosenberg shouldn't be relevant simply because it's about a variance. I'm not sure about, I'm not a lawyer, but I believe when it comes to determining what is relevant and what is not, it should be the argument. It shouldn't be the type of the application. If, let's say, if we're looking at a special permit and we're looking at, looking at an appeal that concerns the special permit, and there is an argument about a use. If there is a case law concerning the use, and this case law is about a variance, why it's not possible to consider this case law as relevant? So I need like a clarification or explanation. Maybe I learned something here, but it doesn't make sense for me simply because that Rosenberg case is about a variance. It shouldn't be relevant. I cannot imagine that. The other point is, bear with me 1 second. Yeah, the conflict thing. The DOB says that if there is a conflict between two zoning clauses in the zoning resolution, the more stringent should apply. Again, my understanding, and again, I'm not a lawyer, if there is a conflict, I believe it should be interpreted for the benefit of the applicant, not the opposite, not the government. So I'm not sure if what I'm saying is accurate or I am missing something. So again, I will need like a clarification from DOB on that. And that's
I just want to pick up on that. That's an instruction in the zoning resolution that where there's a conflict, the more stringent applies. Whether there's actually a conflict is another question, but that's the instruction in the zoning resolution when you have conflicts on interpretation. So they didn't make that up. It's a different subject than that you resolve in favor of the property owner when there's an interpretive, easily can fall on one side of the fence or the other. Okay.
Okay.
Anything else?
No, thank you.
Okay. Commissioner Shabetto.
Thank you, Chair. I want to say Department of Buildings material, I found it, I want to commend them. I found it very concise and to the point. I was persuaded by much of their arguments. I do believe the Department of Building has the authority to reevaluate how it's making decisions and its policy. I believe that when you look at the relevant sections here, it could be argued that these are conflicting in some way. While I understand the arguments that this isn't exactly a radio tower pursuant to technology, etc., that I can certainly understand that. But does the definition of is it a reasonable interpretation of is that a reasonable interpretation? At this point, I believe it is closer to a reasonable interpretation. And if there is a conflict, I believe it's not an arbitrary decision from the Department of Buildings to suggest that this is akin to a radio tower as opposed to a equipment structure. And I did find their argument that equipment structure, when you read the rest of use group 6B, how the parameters around structure does lend itself to the definition that Department of Buildings had proposed, that these structures were actually going to be building-like, and that you'll see that in furthering reading use group 6D definition. So at this point, I have to say I'm much more aligned with Department of Buildings' position on this case.
I just to clarify, because I didn't quite hear the word you said, that the structure would be building-like. Is that what you said?
Sure. If you let me get the actual language. So it equates telephone exchanges or other communication equipment structures In all districts, the height and curb level of such structures not existing on 750 shall not exceed the attributable to a commercial building of equivalent lot coverage. Now, I'm not saying that this, and you keep going through that sentence, but I'm not saying that this is dead on, but it certainly supports the argument that what was intended by other equipment structure may not have been a monopole based on this type of definition. Again, it's not a home run, but I think it's much closer on the side of the Department of Building.
Okay, thank you. Thanks, everyone. Anybody else last minute? Yes?
I just wanted to add the application of 1122, if we are saying that the 7330 is a bulk thing and use group 6D does have the use and the bulk embedded in it. And therefore to say that we should use the more, the extreme, the more, what is the restrictive one should be used. First, one needs to exhaust what's there that's permitted and then go to the, and so I'm having difficulty when applying 1122 here in this case, because the use does give you the ability to build within the sky exposure plane and gives you the limitations and how to assess that. And if it fails, then, and I'm not sure how automatically the 1122 gets triggered here. I'm not quite there yet on that.
1122 being the more restrictive, is that what you're talking about? What is that what you mean? You're muted.
Oh, I'm sorry. Yes, that's what I meant. ZR 1122.
Mm-hmm. Okay.
Okay, this concludes the public review session for September 14th, 2020, 2 p.m. session. We will now commence with the public hearing for September 14th, 2020, 2 p.m. The following case, item number 21 and 22, 2017-16A through 2017-19A, 1558-62 Clintonville Street, 150-93-95 Clintonville Court, Queens, and 2018-105A, 150-87 Clintonville Court, Queens. The applicant in this is Sandy Agnostu.
Mm-hmm.
The owner, I think, is also appearing.
Okay, when you can hear us, please proceed.
Yeah, you don't have to be sworn
You
in.
need to be sworn in, or wait a minute, this is a GCL waiver.
You don't have to be sworn in, I said.
Yeah, okay. So please proceed, you can hear.
Yes, good afternoon. Sandy Agnostu, representing the office of Gerald Caliendo Architect, and the owner, Mario Ferrazzoli, is he's also there, as well as our counsel, Todd Dale. So we are in discussions with the DOT along with our counsel, and as the chair summarized in the review session, I think she summarized it well, what has transpired up until this point. So at this time, DOT is considering a couple of options and having internal discussions on the borough level. So we appreciate the board's efforts on this. They've been very patient with this application. So we would just be asking for some additional time, at least a month, so that we can work together with DOT and come to a resolution on this, so that the result will be a plan that's acceptable to DOT, to the board, and that the owner can work with.
Mm-hmm. Okay, I would just like to ask you to have a back pocket solution in case negotiations fail. I mean, it'd be a real shame if they fail, because you heard, I really do think that the site plan that you provided most recently with the turnaround that comes from 150th Place is a really good project, great improvement over what we saw before. But that, let's, for argument's sake, say DOT says, no matter how much we beg, And it's so hard to understand why they wouldn't want your client to take over control of that little spur of 16th Road, but nonetheless. So to come up with an alternative plan that you would actually want to develop with frontage solely from Clintonville. Okay, and yeah, that doesn't rely on GCL 36 waiver.
Okay, so I heard the comments in the review session. We did submit an as-of-right plan, but we will look at a better design. We heard the comments that the chair made about setting back and possibly including a fifth building, and also made reference to another case, which we will look at that so that we have an alternate solution in case the DOT just doesn't work out.
Okay, all right, thank you. I'm not 100% sure that the setting back with frontage from the street actually works, but it apparently was working for this other case. And Tony, maybe you could, you know which case I'm talking about, right? That has the sort of a triangular section that fronts on a map street, and then there's the DCL 36 application, and then the unmapped street behind it. And they're saying that the houses that are across the street of the unmapped street are considered to have frontage. And we all found that really hard to understand, but this is much more direct frontage than that one. You know what I'm talking about?
Was that Eric's case?
No. Todd.
No, Todd. It's Todd's case? Oh,
It's our
Todd's, yeah.
case. I'm familiar with that.
okay.
okay.
So you're familiar. So I don't know if it's a viable approach, but if it worked for one, then it might work for the other. Okay.
Okay, we will definitely look at that and work with Todd.
Okay, great.
Lastly, I'd like to mention that we had discussions with Community Board 7. They reviewed our plan. They had a few comments about the
Rear line.
rear lot lines, which we revised and resubmitted a plan, and they recommended approval of the application based on the latest revised site plan. They also had some questions about who would maintain the cul-de-sac and fire service and sanitary storm services, which we responded to.
Okay, great. Thank you. Any commissioner questions, or we'll move to the public? Okay, so we can invite the public to participate in this call.
This is 2017-16 through 19A, Clintonville Street, Clintonville Court, and 2018-105A, Clintonville Court.
Okay, so, while we wait to see if anyone's going to call in, so you're asking for a month. You can let us know also as you make progress, whether you need more time, but I'll make a note that a month is what you're looking for. It's kind of like a month to submit, right?
Yes.
Yes, okay.
It's a month submit to another revised plan, but also with DOT, right?
Yeah.
Sandy?
Right, to give DOT time to.
It may not be enough time. I know that they're really strapped for staff and time and so on. It may not be enough time for them, but in the meantime, of course, give us a viable alternative plan in case that's what ends up happening because DOT won't agree, okay?
Okay, so should we maybe request 6 weeks to give
Okay.
a little more time?
That's fine. Mhm. Okay. All right. I don't see anyone calling in. So thank you very much for participating, and Mr. Farazzoli also for calling in. We appreciate the owner's participation.
Thank you.
Okay.
Thank you.
Item number 23, 2019-281A, 965 Richmond Avenue, Staten Island. This is Singular Wireless, the firm of, I forgot, Fisher something, Fisher Cuddy Fisher. Sorry. I'm sorry, thank you, Julie.
Do we have everyone in? No.
Not yet.
Okay. Please state your name when you can hear us.
Hi, good afternoon. Chris Fisher on behalf of the appellant.
Okay, and I see Mr. Walker also is in the waiting room. There we go.
Okay, so DOB is here.
State your name, Mr. Walker, when you can hear us.
Hi, this is Michael Walker with the Department of Buildings.
Please state your name when you can hear us.
Can you hear me now?
Turn
Yeah.
off your YouTube video, please. Someone has feedback. Okay, I saw Felicia Miller for a minute in there. Maybe she left.
Can you hear me?
Yes.
Yeah, we can hear you, Michael.
Good. This is Michael Walker with Department of Buildings.
Okay, Mr. Fisher, you want to begin?
Yes, thank you. I just want to start off by thanking all the commissioners for the time and effort you've obviously expended on review of this appeal. There have been a number of different submissions. This is our third appearance on a hearing. I want to try to simplify the case. We've essentially, in the course of several months, unpacked a lot of zoning history and building department's history with respect to cellular facilities. This particular case involves an appeal solely on the question of use. The questions come up related to skyplane exposure and other types of bulk and area tools that the city certainly uses. And I would just start off by saying this site actually complies. That was part of the analysis that was submitted by the applicant when it actually filed with DOB. The sole objection is on the question of use and whether or not this falls under 3215 within the zoning resolution as a other communication structure under the use group 6D as we've been discussing, or if instead it's a radio or TV broadcast tower that would be classified under 3230 and require a special permit in a commercial zone. As far as some of the materials that I saw DOB submit, I really just wanted to highlight a couple of things. It's pretty clear to me that the city DOB's major concern is excessive cellular monopole height. And we had spent the time in some of our prior submissions going back to April to document thoroughly for the BSA that that's just not an issue in this industry. The highest by right monopole that we could identify of the 30 plus that have been permitted that way in the city was 130 feet in height. All of these facilities complying with either skyplane exposure or other bulk and area requirements as they were permitted. Some of them even have certificates of occupancy as a use group 6D particular use. So the question really at this point in time goes back to what has the DOB done over the last 20 plus years in classifying these particular uses. And I think one of the things we've got to focus on is that the DOB formally issued a written interpretation. And I know there's been some discussion of, well, was that in the TPPN or was it somewhat vague or not? Right after the TPPN was issued, and this was in some of our initial filings, Commissioner Visconti at the time, and it was in September of 1998, wrote a letter dealing with this exact question. And the response verbatim from the letter was that monopoles and communications towers, if they're for telephone or other communications, as in use group 6, would be permitted in commercial and manufacturing districts if they're in compliance with the zoning resolution. That was copied to borough commissioners, general counsel, and others. That is the actual formal interpretation that we are dealing with that has been applied nearly routinely for the last 20 years. There's one exception, and I think the DOB submission pointed out, we pointed it out months ago as well, that we just submit was in error. An applicant went for a special permit, but if you look at the universe of these types of monopole facilities in commercial and manufacturing districts, overwhelmingly have been permitted by right. So the question really at this point is, why the change? What support does DOB have for that change? And frankly, what would be the proper process? We've submitted all along, there is a burden on the DOB here, and you can't simply change a legal interpretation of a zoning resolution, even if there might be some policy considerations that are giving you pause. In this case, it seems to be height and a concern over height. While we don't see that as a pragmatic concern, certainly not something that's demonstrated by the factual record of 20 years of siting in the city, I would also submit the proper way to handle that, if there's a change in concern within DOB, would be to ask the Planning Commission to come up with a new regulation. We addressed it in our reply, but it could be something as simple as, instead of the 6D bulk requirement and sky plane exposure, we're going to insert a new height restriction when it comes to by right cellular monopoles in use group 6D, maybe limit it in terms of height, under 200 feet or something of that nature. There are options if the city is concerned about that. But from a legal point of view, I don't believe that the Department of Buildings has the authority to simply forego its prior determination without some burden that there's a relevant change. And frankly, here, there hasn't been any legal relevant change. Even if we dismissed 20 years of history here between DOB permitting by right, we still have Rosenberg to address. And that was, in fact, the reason why DOB acted the way it did in 1998. Even without that history, the Department of Buildings would be in a position, at a request of an appellant like ourselves, in having to classify this use. Is this use a public utility like other public utility structures, not just buildings that are under use group 6D, whether it's electric and wastewater or other facilities? Is it a use that falls under use group 6D, specifically other communications equipment structure, or is it 3230 radio TV tower? Fundamentally, the Court of Appeals answered that question. So in the absence of some other specific express legislative act by the Planning Commission, which that to me is the most important legislative history, is that there is none. We've been dealing with cellular facilities for 20 or 30 years, and the Planning Commission has not sought to regulate this particular area. Instead, looking at it and saying, okay, we've had certain exemptions, we need special permits in residential zones, and certain things are by right, and that seems to be working. If the Planning Commission wants to address that, certainly they can address that. That's where policy belongs. But in this case, I don't believe the DOB has established or met any burden of proof to change what the history's been here for 20 years. And the chair asked a good question in the review session, why is the applicant concerned with this? And if this was a one-off and we were simply dealing with one site where I suspect we might for a couple of years, you're absolutely right. Maybe we should just apply for a special permit. The concern, and it's still an issue, although it's not legally before the BSA on this appeal, is that the DOB has not addressed the 30 plus towers that were permitted this way. We believe they've taken the position they're not illegal. They weren't erroneously issued permits under the interpretation I previously cited by Commissioner Visconti, but that for whatever reason, there's been a change in how they're now going to interpret this going forward. My client has 6 facilities at least that it would like to modify, whether it's to change an antenna and upgrade the technology, 5G or otherwise, that it has not been able to actually do. And this legal question is still pending. So this particular issue, while it's not necessarily precedential on how it might address it, I'm getting the clear sense that DOB has not acted on our requests because this appeal is pending. So this is tied up in a little bit more of a broader citywide question, not simply is a 77-foot monopole at this particular shopping center in Staten Island appropriate, and why has the appellant sought their appellate rights? That's why we've sought it, and we have some concerns. So we believe fundamentally the DOB has a burden of proof here. They're focused on height. If that's the issue, the Planning Commission can take it up, but that is not a reason, nor is it supported in the law, to actually say that the use is somehow a radio TV tower. The only way the DOB gets to its outcome that it's looking to achieve from a policy point of view is if you really strike the words radio and TV right out of the zoning resolution altogether. When I read the DOB's papers, what they're essentially saying is, we think fundamentally all towers in the city, regardless of what kind of tower they are, what kind of use they involve, should go to the BSA because that's the best way to address bulk and area height of monopoles or other tower structures. That's not what the zoning resolution says. And under the rules of construction, it does need to be interpreted not only in accordance with law, but in a way that's favorable to an appellant. And I believe under all those scenarios, there's really no way for the DOB to justify its action in revoking actually a permit that had been properly issued. We submit that This is a use group 6D, it's a cellular facility, and if for whatever reason the planning commission seeks to change by right in commercial and manufacturing zones or change the sky plane exposure as applied, it would be something that they would have to take up legislatively.
Thank you. I just want to clarify one thing. The Rosenberg case didn't discuss whether whatever the facility that was being considered as a radio or a TV equipment. It was only looking at whether or not cellular equipment would be considered a public utility. I just want to clarify that because your sentence was a little confusing. But I also, I'm still looking for that clarification that you had in your papers, twofold. One is that all of the applications that were submitted to the BSA were under the special permit 7330, which has to do with radio TV towers. And there was no objection to that by cellular industry saying it's mischaracterized. And the second is the question of why Omnipoint in that BSA case that considered this authority to issue the TPPN in the first place said we are not communications equipment. If you could address those two questions.
Yes, absolutely. And you're correct. The Rosenberg case dealt with cellular facilities and how they would be classified as utilities. Did not address whether or not radio or TV towers are utilities. Although the Court of Appeals in a separate case involving the BSA actually in Fordham addressed radio and TV towers, but they're not public utilities, radio and TV towers. As far as
the Fordham case did not question whether that's a public utility because that particular radio station was for Fordham University's communications department. But I doubt that you would argue that WNYC or any of the television stations are not public utilities. They're the same. The whole idea of radio transmission and television transmission for the general public is a public utility, and Fordham did not stand for the proposition that it isn't. Only Fordham University's own radio tower for its own communications department.
Yes, that was.
And I just want to further that just a touch more. In Rosenberg, the decision, the finding of it being a public utility was specifically tailored to the hardship question, as opposed to like this broad spanning. I feel that applying that as fact dispositive in this case is a bit of a stretch.
Respectfully, I disagree. There are cases, including the Meyer case we cited in our materials, that talk about cellular facilities as public utility, whether they're attached to a structure or a tower, and that's the law of the state of New York. So, and the court, when you look at the case, went through fundamentally why cellular is a public utility and has to be classified as that in the absence of a specific personal wireless or cellular regulation locally. So I would respectfully disagree. And as far as other radio and TV broadcast facilities, even those that are not accessory, I don't believe those are classified either as public utilities. They may have a public purpose, but they're not public utilities in the same sense that are entitled to protection under Hoffman and obviously Rosenberg.
But they're regulated by the FCC and by the public service, public services commissions of the different states. So then how are they regulating that if it's not a public utility?
Yeah, fundamentally, they have a regulatory construct to them, but they're not actually providing utility services in that context. So when you look at all the cases, it's really coming down to telephone services, two-way services, electric distribution, not radio or TV. They certainly have an important public purpose, but they're not public utilities and entitled to that same protection under law. As far as some of the prior BSA proceedings, and I wanted to address the two questions, Chair, you were asking under 28705A. That matter involved a third-party appeal to the BSA seeking to overturn the TPPN as beyond the jurisdiction of DOB. And in upholding the TPPN, the BSA looked at its purpose, looked at the definitions within section 6D, actually, in terms of telephone exchange and other communication structure, and ultimately concluded DOB had authority to issue the TPPN, which created an exemption. That's what it did. And as far as the scope of the exemption, it was very clear. Antennas on rooftops and those types of structures that exist in residential zones wouldn't be subject to the zoning resolution. What happens when something doesn't meet those various requirements that the TPPN lays out means that the actual use itself, the structure, is subject to the zoning resolution. And so when the BSA was reviewing that particular appeal, I think, and I'm speculating because all I have in front of me is the resolution itself, and I was reviewing the provisions you were referencing where OmniPoint seemed to be making an argument. My take on their argument was simply this. Their concern was that in that case, because it involved antennas, and just to be general about it, bolted to the roof of the building, it didn't involve some kind of superstructure on the roof of the building, and it certainly didn't involve a monopole at grade. I think their concern, while I don't share it, was that somehow the antennas themselves wouldn't be deemed a telephone exchange, as that language is used, or other communication structure, and that somehow the DOB would interpret it outside and therefore prohibited, which would put them into use variance classification. I don't share that same concern. We've dealt with this in other jurisdictions, telephone exchange, and certainly broadly construed, and that's what the antennas function as, the provision of services, and they're connected into the public telephone switch network. So I'm not sure the full scope of OmniPoint's concern, but I think that's what it was, that they didn't want to have their facility, if the TPPN was invalidated, deemed prohibited, and therefore every time you put antennas on the roof of a residential building in the city of New York, you'd need a use variance. That would be my analysis, at least based on the tenor of that case and the time it was argued.
But it was in the context of a TPPN saying you don't need a variance. You don't need anything.
Right.
So we're objecting to being treated more liberally.
No, I think OmniPoint wasn't the appellant in that case. They were simply trying to defend the TPPN. And I think they were trying to suggest to the BSA, if the TPPN isn't upheld, we have these major other issues in that every site we do on a residential building is going to need a use variance. I think that was the tenet of their argument, even though they would have the benefit of Rosenberg.
Two sides of mouth. Okay, thank you. Any other questions for Mr. Fisher? Other commissioners? No? Okay, thank you. So, Mr. Walker?
Good morning.
Afternoon.
Oh, afternoon, yes. My name is Michael Walker, Assistant General Counsel with the Department of Buildings. In the last hearing, the board requested more information from the appellant on the relevance of the Rosenberg case to the instant matter, which is a question about use interpretation. The board also inquired into whether the zoning resolution would suitably limit a hypothetical structure that has a 10 by 10 foot base with an enclosure below the antennas. The issue before the board today is not whether to grant a special permit or a use variance, as was the case in Rosenberg. Rather, the issue is what is allowed as of right without any discretionary procedure, such as input from the community. The department agrees that Rosenberg affords deference to cellular companies. Through TPPN 5 of 98, the department created a scheme that affords cellular companies such deference. The department exempts antenna installations from zoning regulations if they meet the requisites of the TPPN. In addition, the department allows antenna installations in or on building-like structures to be classified as use group 6D, telephone exchanges or other communications equipment structures, since, as the letter from the City Planning Commission explained, doing so would not supersede the underlying district bulk regulations to which the underlying building would be subject. In contrast, where the structure is an at-grade tower that lacks the bulk of a building, it falls within the classification of a TV or radio tower use and is also allowed, but with a special permit from the BSA. There's evidence that there was not consistent department interpretation. As the chair noted in the executive session, BSA has heard cases for towers in C or M districts under zoning resolution 7330. However, to the extent that the department allowed these at-grade towers in the past as other communications equipment structures without a special permit, it was an error, as such use should have been classified as a radio tower. The village of Dobbs Ferry in the Rosenberg case did not afford such deference to the cellular provider. First, the cellular antenna installation in Rosenberg was not a permitted use under the village's zoning code. So the cellular provider had to apply for a use variance for it to be allowed at all. Second, the Rosenberg court overturned the zoning board's denial of the use variance because the village zoning board failed to apply the public necessity use variance analysis, which is suitable to public utility applications for use variances. By failing to apply the public necessity test, the village board effectively disallowed the use in the village. Unlike the village of Dobbs Ferry, the department gives deference to cellular antenna industry. Firstly, antenna installation that was at issue in Rosenberg included 9 antennas, each measuring 4 foot 1 inch by 10 inches, affixed to a water tower use independent of supporting the antennas, would be allowed under TPPN 5 of 98 without the need for a special permit. Secondly, the department is not rejecting the proposed 77-foot cellular tower completely. It is only requiring that the applicant obtain a special permit from BSA. The test in Rosenberg would kick in at the special permit review stage, but the appellant has not yet applied for a special permit. Instead, the appellant wants the board to interpret the proposed use in such a way as to allow future standalone cell tower applicants to sidestep their Rosenberg burden of proving public necessity. In other words, the appellant seeks an interpretation that would make the use as of right and not subject to board review, as was required in Rosenberg. We agree with Rosenberg and already give deference to cellular antenna applications. Further, a radio tower use classification does not preclude a tower from being considered a public utility for purposes of a Rosenberg variance analysis. Thus, a discussion about Rosenberg, in other words, a discussion about whether the board should grant or deny a special permit, is premature. The board also asked how the department would classify the use of a hypothetical structure with a 10 by 10 foot base and an enclosure below the antennas. The answer is that if the enclosed area were just a base to support the antennas, we would not accept it as a communications equipment structure. If, however, the cellular tower were above a building with a use independent of supporting the antennas, then the structure may be classified as a communications equipment structure. The department's and the City Planning Commission's analysis of the zoning resolution, further detailed in our submissions, found that use group 6D applies to building-like structures specifically and not to tower-like cellular structures that can extend beyond the height of other buildings in the neighborhood, and they lack the land use characteristics of a building. The zoning resolution classifies such structures as radio tower, which are permitted in commercial and manufacturing districts through the special permit process in place for radio towers. Appellant claims that the industry is unlikely to propose a 400-foot at-grade cellular tower in the city because of the nature of the current cellular services in the city, and therefore urges the board to not consider that when interpreting what is allowed as a use group 6D use. However, if the zoning resolution provision regarding use group 6D is read to include non-building type structures like radio towers, it must be understood to authorize such heights. As technology demands change, we can expect that so will the shape and locations of infrastructure necessary to support such change. The zoning resolution must be interpreted so that it does not allow such towers as of right, and the department cannot rely on the appellant's anecdote that it will not go that high. Finally, regardless of whether the board considers that this could be classified as a use group 6D use, zoning resolution 1122 dictates that the provision which is more restrictive or imposes higher standards or requirements shall govern. Here we're comparing the restrictiveness of a use that requires a board special permit versus one that is permitted as of right. The special permit process is more restrictive because it gives the board discretion to deny or place special conditions upon an application. The same discretion does not apply to a use that is permitted as of right. Therefore, if the board finds arguments for both use classifications persuasive, the radio tower use requiring a special permit subject to board denial is more restrictive and must govern per section 1122 of the zoning resolution. The department believes it has addressed the questions raised by the board at the prior hearing and the executive session. It also believes it has explained that the city has given deference to cellular communications installations and that Rosenberg analysis is premature because the applicant has not yet applied for discretionary approval. Lastly, freestanding at-grade cellular antennas are not use group 6D communications equipment structures. Rather, they may be classified as a radio tower and eligible to be erected via a special permit from BSA. The department therefore respectfully requests that the board deny the applicant's appeal of the department's denial of the proposed 77-foot tower as an as-of-right use group 6D use and instead uphold the department's objections to file for a special permit.
Thank you.
Thank you.
So Commissioner Schitt had a number of questions. Can you respond to them, or perhaps you need them repeated?
Sure.
Write them down.
I think the first question involved, will DOB go after past or existing towers or past applications? And the answer is that the department does not intend to go after past applications. However, if an existing tower were to apply for a modification, then they would have to comply with the new interpretation.
But what would that mean? So you have your existing monopole already built, and you're going to add new, different, whatever antennae to it. So what would that mean? Because you're not applying to build a new monopole, and if you were, it would be to replace the old one. So it's a replacement in kind, maybe for structural reasons. So what would that mean? You may not be able to answer this, but you can guess.
Okay, well, putting aside that, I think that what would happen now is that putting aside any arguments about tertiary rules related to rights of in-kind replacement of parts, but speaking only from the perspective of the use at issue here, the interpretation at issue here, and the zoning resolution, the department would object because they would be modifying a tower that, and based on a use that we now interpret as a radio tower use. So there would be, the department would object, and then the applicant would have to file an appeal with BSA for a special permit.
So I'm confused, and I can see Commissioner Shonda's hand up. I'm confused. You need to do that again. I have an existing tower. Let's forget about the one where we're tearing it down and putting it back, because that's a different argument. I have an existing tower. All those little antenna, need tweaking. Some can stay. I have to add new ones. I apply to add new ones. It was an as of right under a prior interpretation. What would happen?
The department would object. The normal process in place for, we would object if the use is not, if they are trying to do something that the zoning resolution does not authorize for a radio tower use.
What's not authorized for a radio tower use? You mean putting the antennae on it? Where does it say you can't put antennae on a radio tower? I'm confused still.
Maybe I'm not understanding the question,
So
but
I have my monopole.
Mhm.
We're calling it a radio tower, but it's a monopole. It's a pole, right?
Right.
It's a fat flagpole, really a tall, fat flagpole, onto which at the moment are mounted as of right. The pole was built as of right, and the antenna were mounted onto it as of right. And now, if I'm assuming maybe I need a permit, I'm not sure if I need a permit, but let's just say I need a permit from DOB to install additional antennae on it. The structure is already built. All I'm doing is changing up the antennae that I'm strapping onto it, however they're strapped onto it. How would DOB, what is DOB objecting to?
We would object on the basis that it is a radio tower use that does not have a special permit. Therefore, in order to do the modification, it will be up to the BSA to grant a special permit.
Isn't it a non-conforming use at that point? If you decide, sort of non-conforming, your policy changed and it rendered arguably stuff that was built as of right, because they're not illegal, they become non-conforming. It's a legal non-conforming use. Yeah, I just wanted you to answer that, and then Commissioner Shanda, please do chime in.
Okay. I can take the issue on whether it would be a non-conforming use back to DOB. Of course, if there are valid arguments for that, we're open to considering them because we're being objective here.
Yeah, I'm just curious. What I'm hearing is that DOB doesn't really necessarily know what it would do with this, because it hasn't really thought through the application that I just described. It just knows it doesn't want these to go forward for some reason, but you know, it like signs, you know, with the signs, it was very clear. All of a sudden, there's federal determinations about highway beautification. We're not in compliance with it. There's a zoning resolution change, and DOB has to sort of dig in and disallow all the signs that are within X distance of the arterials and parks and so on. That's clearly a mandate that DOB has to pursue. But on what mandate do you start pursuing what was already and even with respect to signs, you had to leave alone the signs that received legitimate permits by the time the zoning resolution was amended. They just have to establish that they were legally permitted. So how can you, you know, retroactively, effectively rescind approvals? That doesn't sound like it would hold water. Commissioner Shanda, did you want to?
Yeah, I mean, this answer from DOB really threw me off. I'm thinking in a very simplistic way of, let's say you have a zoning district that allowed, multifamily building. And then the zoning district changed to allow only two-story semi-detached home. Does that therefore make that building totally, if any changes that has to be made within the permitted built envelope, I see the changing of the antenna is like adding more windows to your building facade. It's not changing the footprint. It's just adding more windows to the facade. And you have to then seek a special permit if there was available, or a variance or whatever at BSA to allow that. I find that very odd. I think DOB is mixing. I think it seems you're trying to mix the fact that there is going to be a proliferation of towers, and that you have this technology that may result in a lot of cellular network all over the place, and how do we control the proliferation of it, and all the various the various RV rate, RV and other energy levels that are going to be emanating from that. And it's like putting all of that into one and trying to address it through this mechanism, to me seems totally not consistent with the way DOB, city planning, BSA, we have all approached in determining uses that become non-conforming or non-complying. So I think there has to be consistency that has to be applied here. And I still think that now you're going back to the fact that having having more than, if there were 10 antennae and you're going to replace those 10 antennae with 10 or maybe 11, if those same antenna were going to be on the roof from 10 to 11, you would be okay under TPPN, but somehow or the other, the moment that 10 to 11 antenna changeover is happening on a monopole, it then falls into radio TV. To me, that it almost doesn't make sense. Second, an antenna is an antenna. If you're going to allow 10 antenna on a rooftop through TPPN or through use group 6D, and now all of a sudden that and allow that change to be non-conforming on a monopole, to me, there's a mismatch.
Yeah.
Well, I should clarify that I'm not saying that the department would rescind approval for the underlying tower structure. What I'm saying is that when a request for modification comes in, taking an example with a slightly different hypothetical, if it were an existing, if it were, say, a new tower, let's say this tower gets approved with a special permit as a radio tower use, and then went to go get a modification, the department would send it back to BSA for confirmation that the proposed changes comply with the.
No.
That's a completely different thing. Once it's at the BSA, they're married to us. Whenever they make a change, give or take, they have to come back to us for a modification. And some of these monopoles, we have copies of them, got certificates of occupancy in addition to that. You can't claim that it's an illegal use now. I have a certificate of occupancy. And the ones that don't have a C of O have lots of paperwork to establish their compliance with building code and zoning and so on. I'm very, I don't think we need to go down this anymore, but DOB needs to clarify what its plans are, because you're about to get into some serious hot water with the industry, lots of lawsuits, et cetera, because you're shifting the way everything is approached by qualifying this somehow as an illegal use just because I switch out a little thing that's hanging from the pole with another thing that's hanging from the pole. Sometimes the things that hang are big, but sometimes, as we've seen, be small. And all of a sudden it triggers that it needs a special permit that it didn't need before. Totally confusing.
Right. And also,
and I would say, and I would add, it also seems to be contrary to the argument that you presented in your last submission. Your focus is in the building form. If the building form has already been approved and has therefore been grandfathered, and you're not taking into consideration number of antenna mounted on it, then why is that all of a sudden becoming a radio TV characterization? So there's a mismatch in the statement that's been made and how it's being applied.
Well, because the issue of future modification wasn't before us now, it's not something that I was unnecessarily prepared to go into detail on at this moment. But if it's something that you would like us to submit something in writing, I'd be happy to do that.
No, I mean, it came up because appellant's counsel said it's the reason we're not applying for this special permit here is because we would if it was just this one, is because we're afraid about what's going to happen to my client's other 6 existing towers, and not to mention industries, other, however many, 14 or 20 other towers. And so they want to get a resolution on what animal is this thing here at the BSA, so that they can avoid what you're describing being sent to us to sort of like legalize something that already exists. Kind of confusing. Commissioner Sheta, I'm sorry, you had your hand up for a while.
That's okay. I just want to, I feel like DOB doesn't have a clear vision of what they are heading to or towards. I believe right now they don't have a plan to differentiate between somebody who want to like do a structural alternation, for example, in an antenna tower on a monopole, or somebody else who got his tower permitted and he just want to change an antenna. So they need to think like seriously about that. And I'm glad that they mentioned that they are not gonna like unpack the already permitted towers. So that's fine from now on forward, but I believe they should have a plan in place on how they're gonna handle any like requests from owners to do structural alternation or like do modifications in structures like these.
Mhm. Okay. Okay. Any other questions, comments? I see Ms. Miller is on the call. Is there anything that you wanted to add?
No, I don't have anything to add. On the issue, if you feel like you need to have that more answers on what we would do in the future for future modifications, that's, obviously it's a bigger question. It has FCC implications. We would have to review that on a separate matter. So,
Right. Understood. Okay. Thank you. Okay. Mr. Fisher, is there anything else you wanted to say?
Yes, just a few things in reply. This issue with the existing towers is a major and a significant one. I think you, the chair, and Vice Chair Chanda recognized it appropriately. We have gotten objections and denials for simple antenna upgrades on numerous sites. The objection continually comes back. This is radio, TV tower, go get special permit. We've sought clarification on, does that mean that you believe the tower is either non-conforming or somehow even worse, was erroneously issued a permit, which I don't think I've heard to be the case, because that would even be more serious in terms of a concern. But still, for us as an industry, are we supposed to, when we would change out an antenna, apply for an entirely new special permit? What's the scope of a review with the BSA? We've got to go to the community board, deal with public hearings. And what is that? Because those are really serious issues, we submitted a ZRD 2 technical affairs on one particular site, but it's representative of many that we have pending that are in a hold pattern. We're not able to technically upgrade sites right now on these, I would call them 6 I know of, but there are 30 plus or minus towers that fall in the universe of what we're talking about. That ZRD 1's been pending for months. I think we filed it earlier in the year. We have not gotten an answer to that. And I agree, it's an implication here. What the industry is looking to do, and I said this at the prior appeal hearing, we're looking to work with DOB based on the nature of our industry and what it needs to build out and address legitimate zoning, planning, building concerns, whatever they might be, in a controlled way. We haven't had that conversation with DOB. We'd like it. And we have been holding off on those particular modifications, which fall under a specific unique statute that Congress adopted, that specifically, to make it simple, basically says, if you want to put antennas on a tower and change them out, it's very consistent with how it's been interpreted in the city. It's not a zoning issue. It's just a building code compliance issue, and you have a right to do it. So we've been holding off on any kind of action related to that. We've been trying to work through this systematically. This appeal, it started 2 years ago. As far as just a process where we ended up as far as the revocation, we're no further. So those are legitimate concerns. It's part of the reason why we are appealing and saying what was decided in 1998 is correct. There's no rationale for change. And if the Planning Commission wants to legislate wireless and cellular specifically, that would be a different forum with public hearings.
So I just want to ask a question. Those 6 applications that you have pending, that's to do what?
Basically, at an existing tower site that's in a C or an M zone that has a permit for the tower structure, there's a fenced area at the base. It may be as simple as going in and taking a piece of equipment off of some dunnage and putting a new piece on that's upgraded technology, or going up to the platform of the tower, taking off some antennas, putting some new ones on, putting some equipment on it. It's that kind of, it's not a structural modification, it's an equipment modification. And that's the scope of those types of matters, generally speaking.
And you're required to have a building permit in order to do that?
Yes, typically the industry will apply for a DOB work permit through DOB Now, the antenna filing system. and go through the process of making sure that we're issued, mostly for building code, not so much for zoning.
Sure. Sure, understood. So, and I just want to clarify with Mr. Walker, that's what Commissioner Shanda and I were querying about, that type of a change where it's not physical to the tower itself, it's the equipment attached to the tower or at the base of the tower, might trigger DOB to reconsider what that tower is?
It may or may not. I'm gonna have to take that back and analyze that if that's okay with you.
Okay, well, I don't think we're gonna, because this goes outside of the question that's presented to us, but it was raised by appellant's counsel. So I thought the line of questioning was helpful in us understanding what the motivation is. But I think, does anyone have any other questions? Because at this point, I think we've had all the submissions that we need. And so I think that we can close this. And I'd ask the commissioners to go through the materials before the vote and make sure that they've heard all of the points, because some of the comments that I heard from commissioners indicated a little bit to me that you've forgotten some of what was submitted earlier. So please go through very systematically before you make your decision, so that when you make your decision, because we always need to have a very clean record about why the commissioners are voting the way they do, that when you make your decision that you articulate what it is in the materials that you saw and what persuaded you that it goes this way versus that way. Okay, that's just, and you'll have time to do that. Okay, thank you very much. And I don't think, do we have to open this up for public comment?
I think we usually do, right?
Okay, let's do.
So the case we're discussing is 2018, oh gosh, sorry. 2019-281A, 965 Richmond Avenue, Staten Island. This is an interpretive appeal before the board.
Okay, so there are no further submissions on this, and we'll give it a couple of seconds for people to join in. Okay, so then I would like to make a motion to close.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheffer. I didn't hear you, I'm sorry.
I'm sorry, aye.
Commissioner Shabeta.
Aye.
Application's closed. Okay, thank
Thank
you.
you very much, everyone, for calling in.
Okay, we'll let you know what the new date is.
Thank you.
This concludes the public hearing for September 14th, 2 p.m.
Thank you. See everyone tomorrow, 10 a.m.
Thank you.
Thank you.